this morning to talk to you about a new project, a very interesting project. And I'm very much looking forward to that. And so please give a round of applause if you can.
Good morning. It's a great pleasure to be here and an honor to be able to address you. So my talk is re-examining the legality. Is the mic okay? Because I know we're okay. Re-examining the legality of the use of the veto in the face of atrocity crimes. And for any Chautauquans here, just to explain the veto power of the UN Security Council. So on the council we have 10 rotating members and 5 permanent members. And the 5 permanent members have this extraordinary power that they can simply prevent Security Council action. It is US, UK, France, Russia, and China. So if they prevent action, we don't have the kinds of tribunals, obviously, that we've been talking about. It ties in with Steve Rapp's opening keynote address, why he's talking about the domestic mechanisms. Because if we have blockage at the council, we won't have a Syria tribunal, at least created out of the council. But even before we talk accountability, if we have blockage at the council, we don't have basic humanitarian assistance sometimes. We can have blockage of a ceasefire or provision of humanitarian assistance or condemnation of crimes. So when the Security Council blocks these things, my talk, and I've given you a chart that kind of traces the death toll that climbs during the vetoes related to Syria, the veto is costing lives. So I wanted to go back. I'm going to start in 1945. Where did this extraordinary power come from? And if we go back to the negotiations leading into the San Francisco conference at Dumbarton Oaks at Yalta, we see it's primarily the Soviets who are insisting on the veto power. The US and UK don't primarily insist on it. And in fact, the US and UK say that if a permanent member is involved in the dispute at issue, the permanent member should have no vote, and ergo, of course, no veto power. And I refer to the Soviets, US and UK, because they primarily conduct the negotiations. It's understood China will become a permanent member, but they don't seem an active participant, and France is added only later in. But they do reach the San Francisco Charter negotiations with the thought there will be this veto power, and other countries react quite strongly against it. As might be predicted. There's great consternation. Why should we have this? A lot of arguments about not having a veto. It doesn't work. A lot of suggestions about limiting the veto. None of these prevail. And there's a dramatic moment when one of the US delegates says, I will tear up this charter. Do you want a UN or not? So this is basically what it came down to. In the end, do you want a UN? The permanent members are going to have this power. So in 1945, yes, it was a broad power, but also there was no field of international justice at that time. So 1945 to 46, Nuremberg is just starting. We don't have genocide convention till 48, grave breaches till 49, Geneva Conventions till 1949. So obviously there was really no discussion of atrocity crimes and could you use the veto in the face of atrocity crimes. It's simply not discussed. And you know, how we see the veto being used, for instance, in the Syria situation, blocking chemical weapons inspections, blocking a ceasefire in Aleppo, blocking condemnation of aerial bombardment. Is this in line with the drafters' original intentions? It does not seem to be in line. It wasn't discussed, so I can't say it was not in line. It was a broad power, but these kinds of matters simply didn't reach the council. The main reason, I think, that we see crystallizing a lot of the negotiations, why do we have the veto? It was really the assumption the P5, the permanent members, would be the major troop contributing countries. And if they're the major troop contributing countries, they should have the veto power. So that is kind of the underlying assumption why we have it. I'm okay. So during the Cold War, you all know that we just have paralysis at the Council for many, many years because the Soviet and US vetoes are simply canceling each other out in the respective spheres of influence of these countries. We see GA, General Assembly, exasperation with the veto power manifesting as early as 1946. So the charter is 1 year old, and the GA starts condemning the use of the veto. We have a series of resolutions in the late 1940s, please be restrained in the veto use, and there's genuine fear the Security Council will be a repeat of the League of Nations and will lapse into paralysis. These concerns manifest in 1950 in the Uniting for Peace resolution, where the US is the prime force behind creating a mechanism where if there's Security Council paralysis, matters go to the General Assembly. And they're doing this in the face of the Korean War. They want authorization for the war, and they lead this move to the General Assembly. There can be an emergency special session called to take up matters when there's Security Council blockage. And of course, at that time period, it's a differently composed General Assembly. We're pre-decolonization, so it is seen as an assembly the US and the UK working with the US would want to go to. This process hasn't been used a lot. It's been used about 10 times. So it's not seen as a complete answer to veto paralysis. The General Assembly does have other residual powers to take up matters. They have powers under the Charter. They can debate a broad variety of issues, and there are some limits to the General Assembly's competence. Any kind of force authorization would have to go through the Security Council. And by force authorization, I don't always mean a large-scale force authorization, but sometimes matters such as creating humanitarian aid corridor or no-fly zones to try to prevent aerial bombardment, protection in IDP camps. If you don't have consent of the host countries, these would require a Chapter 7 authorization. So in the 1990s, we have a brief moment of optimism. We're out of the Cold War, and we see Russian and US votes no longer canceling each other out. And it's, of course, in this time period that we have the Yugoslav and Rwanda tribunals created. But this time period appears to be over. I don't quite know what to call it, but we're somewhat hearkening back to Cold War dynamics, or we're not completely out of the shadow, or we re-emerged into the shadow of the Cold War, something like that. I'm in my talk using the word veto power as a bit of shorthand, but also understand it's sometimes an express veto, and it's sometimes a threat of a veto. So it's not apparent what is going on, but a threat has been made, and maybe measures aren't discussed, a resolution is never drafted, because a country has let the others know they're going to block action. We also have the silent or the hidden veto, and that is simply an understanding that a country's politics are such that a permanent member will protect another country, including one committing atrocity crimes. And here we don't even have to have a threat made. Matters simply don't progress at the Council. So we have a variety of uses, and they're all, in my mind, equally problematic because they all manifest in the absence of measures being taken to alleviate the commission of atrocity crimes. So if we look at how the veto has been used in the face of atrocity crimes, unfortunately it has been. Going back historically to the apartheid era, we see US, UK, and French vetoes. They don't create complete Security Council paralysis. The General Assembly is able to take up measures, and the Security Council is able to eventually, for instance, pass forceful sanctions measures. But it is perhaps slowing the UN response. In 1994, in the face of the Rwanda genocide, of course, we don't have express veto use. It is perhaps more lack of interest by the French, the US, the UK to be involved. So they leave UNAMIR in the middle of the genocide, an insufficient force with the wrong mandate, deploying UNAMIR 2 only when the genocide is over, and the French are busy with Operation Turquoise, which allows major Hutu perpetrators to escape to Congo. The US frequently uses the veto related to Israel. I'm not going to condemn all such use. It's not always in the face of atrocity crimes. Sometimes it is. So some uses are problematic. China prefers not to use an express veto. They use the silent threat or the threat. It is why we see such paralysis out of the Council during the Darfur genocide. And for anyone in the room who would want to argue Darfur is not a genocide, I think you're first wrong. But secondly, my arguments apply to all three atrocity crimes. So if we say Darfur was crimes against humanity or war crimes, my legal arguments would apply equally to it. Again, we see the pattern. We have a UN force deployment of a hybrid force when the genocide is over. We don't have minimal measures to protect those fleeing the mass crimes. The Security Council is simply blocked, and of course China is aligned with the Sudanese regime. We have a similar pattern during the Sri Lanka atrocities, during the Civil War. We just have very little response out of the Council. And we have a repeat, and we're continuing having this repeat related to the Rohingya in Myanmar. We do have an express veto by both China and Russia. In 2007, it would have condemned a variety of atrocity crimes, and that is blocked. So in these situations, it's very difficult to determine how many threats, how many measures don't make it to the Council, but what we're simply seeing is a lack of responsiveness. Russia, by contrast, has no qualms about expressly invoking the veto. It has done so 12 times related to the situation in Syria, often joined by China. And I have given you a chart of the 12 various vetoes, and you can see the atrocity crimes being acknowledged by the Commission of Inquiry at the time of these vetoes, acknowledged to be war crimes and crimes against humanity and genocide against the Yazidis. So just to briefly state these, 2011, early on we would have had a demand for the end of use of force by the Syrian authorities, vetoed. 2012, we would have had a condemnation of a variety of crimes, vetoed. 2012, we would have had condemnation of aerial bombardment, shelling population centers, and the use of detention in Syrian government-run facilities, vetoed. 2014, we could have had referral of the situation to the ICC, vetoed. 2016, we could have expressed outrage, or the Council could have expressed outrage at aerial bombardment and indiscriminate shelling, particularly in Aleppo, but that is vetoed. In 2016, Russia and China veto a ceasefire in Aleppo and provision of humanitarian assistance. In 2017, we could have had veto of the condemnation of use of chemical weapons, and that is vetoed. 2017, a demand for documentation related to chemical weapons use is vetoed. 2017, we have veto of the renewal of the joint investigative mechanism that would have attributed responsibility to those using chemical weapons in Syria. There had been an investigative mechanism, but it was only powered to say, yes, chemical weapons have been used or not, and not who was using them. The joint investigative mechanism is briefly allowed to operate and then is vetoed. Then we have veto of condemnation of chemical weapons use. We have a further veto of the renewal of the joint investigative mechanism, and we have veto of condemnation of the use of chlorine gas. Are these the kind of vetoes that were envisioned during the charter negotiations? Absolutely not. They had no discussion of any of this. It was a broad veto power, but as I said, it was on the idea These would be the troop contributing countries. And I mean troop contributing countries as in a UN mission. I realize Russia, as some of the P5 have troops in Syria, and I don't mean troop contributions in that way. So it seems quite distant from what was intended in 1945. And these vetoes are costing lives. If we can't even condemn, now some measures have passed, some presidential statements have passed, but Beth was writing in her book that's going to come out about a lot of the resolutions expressing moral equivalency, was how you were phrasing it, that you see kind of equal condemnation of the regime and all the other actors. So we're not singling out. I don't mean to suggest it's all regime perpetrators. Of course, it's not, and we have massive IS crimes as well. But these vetoes, I think there are vetoes of all these measures related to chemical weapons, it can't help but be something of a green light to the regime. And you put together 12 vetoes altogether, and that also is a green light. Why would there be deterrence in Syria when we know there's a protector or two on the council that will try to ensure lack of accountability and lack of condemnation? So dismay at veto use, I mentioned started in 1946, but that was in the Cold War era. Dismay at veto use in the face of atrocity crimes has started in about 2001. And it comes out by the International Commission on Intervention and State Sovereignty, the Canadian commission that formulates the responsibility to protect, R2P. And one part embedded in their huge report is the responsibility not to veto, because you can't protect populations in peril if you have unrestrained veto use. So the R2P documents consistently say there needs to be veto restraint. It doesn't make it into the World Summit formulation because John Bolton ensures that it doesn't make it into it. Our second veto restraint initiative is by the S5 group of states. They call themselves the S5 as opposed to the P5, and they are Costa Rica, Jordan, Singapore, Switzerland, and Liechtenstein. And they start with a resolution in 2006 and a later resolution drafted in 2012 for the General Assembly calling for veto restraint and a whole other broad variety of measures to increase Security Council transparency and accountability. By written accounts, when pressure is put on the Undersecretary General for Legal Affairs, she declares the issue is an important question, so under the Charter, Article 18.2, it would require a 2/3 GA vote. Pressure, according to accounts, is then put on other states not to vote in favor of veto restraint, and the measure is withdrawn. Our next initiative, and it's somewhat contemporaneous because they start on this fairly early, is referred to as the French-Mexican Initiative. It is really French developed. And this is pretty significant that we have a permanent member of the council saying there needs to be veto restraint. And they come out with a political declaration that there needs to be veto restraint in the face of atrocity crimes. And you might say, why would a permanent member call for this? I'm writing a book on these issues, and I still have more research to conduct. One surmise I might make is that at one point there was a proposal to give the French Security Council seat to become a rotating EU seat. So perhaps France saw itself as a less secure member on the council and therefore more of a need to be responsible in its voting. So it comes forth with this political declaration, Mexico joins, and now we have 96 states endorsing it. Our fourth major veto restraint initiative is the ACT Code of State Act, States Code of Conduct. ACT is Accountability, Coherence, and Transparency states, and it's really the P5 group minus the S5 group minus Singapore who puts this forth. And they pose it that all states have a responsibility to act in the face of atrocity crimes, but it also calls for veto restraint. They currently have 114 states have this, and that's pretty significant because it's almost 2/3 of the General Assembly membership. For the sake of time, I will skip over a similar veto restraint initiative proposed by the elders, which of course had Kofi Annan and Nelson Mandela on it. Our dear friend who is often here with us, Hans Corell, had his own veto restraint initiative. And the US actually even had a veto restraint initiative under the Obama administration. There was a genocide prevention task force chaired by former US Secretary of State Madeleine Albright and US Senator William Cohen. So what I think this speaks to is 20 years of states saying unrestrained veto use in the face of atrocity crimes is problematic. Our huge problem is only 2 P5 have endorsed this, and I didn't mention the UK has also joined the Code of Conduct. But Russia, China, and the US show no inclination to joining these initiatives. For the sake of time, I will skip over analyzing the differences in these initiatives, but to suffice it to say there are slight differences how exactly we formulate the atrocity crimes, whether it also addresses the threat of the veto or it is only the veto use, whether the threat of the crimes should already trigger a responsibility not to veto, how we make a determination whether or not the crimes are occurring. Does there need to be an outside trigger mechanism to say the crimes, or can we say a commission of inquiry, commission of experts report? Can we use the office of the representative, R2P and Office on the Prevention of Genocide, whether these could be trigger mechanisms? Should there be an explanation for the veto use by the permanent member and or some kind of explanation? Is your veto consistent with international law? A formulation I would really endorse. Some states have wanted a carve-out permitting the use of the veto in the vital national interests of a permanent member. And this is in the French-Mexican initiative. I actually think this is deeply problematic. It contrasts completely with the elders' proposal when Kofi Annan and Nelson Mandela said it's never in the vital national interests to veto measures related to atrocity crimes. There is also a carve-out in the Code of Conduct insisted on by the UK when they say, well, we think it should only be a veto that is impermissible of a well-drafted resolution. And then that begs the question, well, what is a well-drafted resolution? So both of these initiatives have a bit of wiggle room. But on the positive side, we have this huge momentum, but it doesn't obviously go far enough, as we see with all the Syria vetoes. These are seen as soft law, a code of conduct, a political declaration. So I think what we need to do is look at some of the hard law legal obligations that exist. There's a huge body of international law. We didn't have all of this in 1945, but we do now. No one is really looking at this. It's assumed, oh, veto is, a carte blanche, can be used for any reason, no reasoning need be given. But I think there are legal arguments we should consider. The first one I would pose is, how does the veto, which sits in the UN Charter, interrelate with Jus Cogens norms? So we say the protection, the commission of genocide, war crimes, crimes against humanity are prohibited by Jus Cogens. This is our highest source of law in the international legal system from which no derogation is permitted. The veto hierarchically sits below it. It sits in the Charter. And there is a hierarchy of norms here. So the word veto is not used but it is read into Article 27.3 of the Charter. So is it acceptable to have unrestrained veto use that allows continued commission of Jus Cogens violations? The Tadic case said the Security Council power can't go beyond the UN power. We have court rulings that the UN is bound by Jus Cogens. Ergo, the Security Council is bound by Jus Cogens. Can it veto in the face of such violations? Dapo Akande writes, Any Security Council decision in conflict with jus cogens must be without effect. Judge Lauterpacht writes that a Security Council resolution that would make members of the UN accessories to genocide is invalid and should be disregarded. Our second argument that I think we might consider derives from the Charter itself. So the veto sits in the Charter, but there's a provision in the Charter, 24.2, that says the Security Council must act pursuant to the purposes and principles of the UN. We then go back to Article 1, which has very broadly formulated purposes and principles. So I'm not going to discuss all of the purposes and principles, but I will ask, is the veto use that we are seeing consistent with the purposes and principles of the UN? Is veto of chemical weapons inspections, etc., consistent with the UN's purposes and principles? Remember, use of chemical weapons, depending on the context, is a war crime, crimes against humanity. Our condemnation of chemical weapons is a very, very old one. This is one of our, very solidly respected norms as a legal matter. And what is exciting is I have on this one heard states make this argument. I have been having some meetings with states on these and suggesting these legal arguments. And this argument was taken up by the Security Council at a meeting I was at on May 17. And I was very pleased to hear one of the elected 10 members invoke this argument. And then it was repeated the next day at a Code of Conduct meeting. And I think this is very important to start this momentum. We've had 20 years of saying, please restrain your veto use, and it's not working. So now states are just starting to see, well, maybe there are actual legal problems. The third argument that I think states could be invoking would be looking at the treaty obligations of the individual permanent members. So all P5 are members of the Genocide Convention that says you have to prevent and punish genocide. So we have the ICJ Bosnia-Serbia decision. And what is interesting in that decision is it says your obligation to prevent depends on your ability to influence. And if we look at the ability of the P5 states to influence, it is certainly an extraordinary power. They have strong positions of influence. Also, if we look at the countries intervening in Syria, particularly those with ties to the regime, of course, they have incredibly strong positions of influence. Similarly, we have an obligation, one more point about of interest of that decision is note that it's talking about Serbia's responsibility vis-a-vis the genocide in Srebrenica. And at the time of the genocide, Srebrenica is in a different country. Bosnia declared independence in 1992, the genocides in 1995. So the Security Council is discussing Serbia's obligation to prevent crimes in another country. Because it's sometimes thought, oh, these obligations are just on your territory. And interestingly, in this decision, it says, no, it's not a territorial limit. So that is also a very useful precedent. The permanent members are all parties to the 1949 Geneva Conventions, at least the 1949, but they contain an obligation to prosecute grave breaches. And they also, in Common Article 1, there is an obligation to respect and ensure respect for the Geneva Conventions in all circumstances. So they're bound by this as a treaty matter. So I simply ask whether unrestrained veto use in the face of grave breaches or genocide is consistent with these treaty obligations of the permanent members. And the grave breaches, I know I'm picking an older formulation of war crimes, but they're very broadly worded. One of the grave breaches is willfully causing great suffering or serious injury to body or health. So this would encompass chemical weapons use. So even to say this old list of war crimes is binding is a viable and valuable argument. I haven't mentioned crimes against humanity, and of course Layla and before that Sharif Basuni have been working tirelessly to have a treaty. We don't yet have it, so we can't make the same treaty-based arguments for crimes against humanity. And we might make similar arguments in other ways by relying on the erga omnes obligations of all states in the face of atrocity crimes. We also might look to the ILC's articles on state responsibility in Article 40 and 41, the obligation to end serious breaches of any peremptory norms. So there are other arguments we could make on crimes against humanity. One caveat I do have to make on my third argument is in terms of the hierarchy of norms, if we have jus cogens, the Charter, treaties are lower on the hierarchy of norms, because if we look at 103 of the Charter, it says treaty obligations that are inconsistent with the Charter are trumped by the Charter. But I would argue these are not just any old treaties, these are foundational treaties in our system that embody jus cogens and protect the purposes and principles of the Charter. So I might loop in my first two arguments to get around this 103 issue. So these are legal arguments I think states need to be considering. I hope scholars will consider these and write about these. I think these arguments can be particularly helpful to the elected 10 members when they're opposing unrestrained veto use. They can now start invoking more legal arguments, hard law legal obligations, rather than waiting for 3 of the recalcitrant members to join these initiatives, which I don't think is going to happen. One could even imagine GA states coming together and saying, we should get an ICJ advisory opinion. Is it fine to have unrestrained veto use in the face of atrocity crimes? It's a simple question. I think it contains 3 subsidiary questions, but I think you win on any of the subsidiary questions. The GA might alternatively go back to trying to do a resolution. I know it didn't work in 2006 and 2012 for the S5, but we are in a different climate. I think frustration at Russian use of the veto related to Syria is particularly high. I think there would be more receptivity to this kind of approach than there ever has been. One could embody some of these ideas directly in a GA resolution, or one might pursue both of these ideas. And I will just briefly suggest as I conclude my remarks and leave us a little bit of time for Q&A, that when I'm looking at these hard law legal obligations, they are the same hard law obligations that underlie R2P. Because we're letting states off way too easily when we say, oh, R2P is just soft law. These are just norms. We suggest this to you. No, wrong. And we've been doing this for far too long. R2P, which is the responsibility to protect formulated by the Canadian ICISS Commission, is the concept we need to protect a population in peril. There are 3 pillars of the protection. But I will say it seems to have been utterly ignored related to Syria. Why? Because of the veto. So R2P needs revitalization. We could look at some of these hard law legal obligations underlying R2P and say to Security Council members, but also to the GA, doing something is not as optional. It's very convenient for them all to say, oh, it's just soft law, but it is not. So if we want to revitalize R2P, we can look at our hard law, and if we want to try to limit use of the veto power, we can start looking at hard law legal obligations. I'll end here. Thanks.